Hi, I'm Cal Barron and welcome to RWK Goodman's Legal Thinking podcast. In the legal industry, loads of people have claims of either clinical negligence or their own personal injury claims. But what happens if you have ones that cross over between the two? How does that process work and what does a crossover claim look like? Joining me today to talk about these two topics are two of my guests. So I'd like to welcome Rosie Hodgetts, an associate in RWK Goodman's personal injury and clinical negligence team, and Rhiannon Frowde, a barrister from Chambers 3PB. Welcome to you both.
Hi.
So Rosie, I'd like to start with you. What exactly is a crossover claim?
Okay, so these are the sort of claims where somebody's suffered a personal injury and then superimposed onto that is clinical negligence. So, for example, perhaps somebody's been injured in a road traffic accident. They go to the hospital, they have negligent medical treatment, and you're then looking at this case where, as well as this original personal injury claim, there's also a claim for this medical negligence.
And how generally does that arise? So in terms of someone going to a hospital, surely is there some continuation between that personal injury going into clinical negligence at times, or is there a very clear divide between the two?
So it's quite difficult, and this is probably where, Rhiannon can step in as well. But I mean, usually, I think what you're talking about here is the chain of causation. So, what you're looking at is the reasonable foreseeability of the outcome with the original event. So, somebody perhaps has had, again, road traffic accident. They've had, some scrapes, some cuts, sort of degloving type injuries. They go to the hospital, that's not properly cleaned out. They end up with quite an extensive infection, which perhaps leads to amputation. Now, what you're looking at, is it reasonably foreseeable that with that original accident, you then end up in a position where you have an amputation? And is it fair to be claiming all of that against the original car driver? Or are we saying, actually, do you know what the hospital has done is so negligent that that's broken that chain of causation, and this is something coming in separately?
And Rhiannon, in your experience as barrister, how has that kind of played out to date?
I mean, there is quite a little bit of a messy case law background on this front, but it's quite a common, unfortunately, inherently, that when you're going to have a personal injury case, usually this necessitates a degree of medical treatment. So by necessitating a degree of medical treatment, most slightly more complex personal injury cases are open to the possibility of then developing a clinical negligence aspect. So in practice, ideally, we won't be seeing too many of these, but in reality, it's something that I think a lot of both claimants and the defendants need to be live to the possibility that, especially when you're seeing results that look a little bit poorer than you'd expect, that it might be important to start looking at joining in the medical practitioners or the hospital trust in these cases.
I guess, how does that kind of arrive practically in terms of that process going through? So when someone suffers an injury and then they have, a less than ideal experience at the hospital, some may say, how do they go about pursuing that legally? Do they go, I would like to do both, or is it?
No, so I think sort of very often, and I don't know if this is Jan's experience as well, but you start with somebody who's had, just one, they think they've got one of the two. So they're either coming to you saying, I think I've got a medical negligence claim because, I had this scrape, it wasn't treated properly, I've ended up with this amputation. Or they're saying, I was involved in a road traffic accident and, this has been the outcome of it. And, most cases are very medically led. So we would be instructing medical experts. We'd be saying to them, can you have a look? Can you comment on the injuries? And either there would already be a suspicion where we'd be saying, actually, when you're looking at this, can you also have a look at the medical treatment and the standard around that? Or it might be that, they may flag it as well and say, when I've been reviewing these notes and looking at this, I just think that the treatment that's been given here in this situation is probably negligent. And then that sort of opens up that conversation to say, well, is that sufficiently negligent? Are we looking at a claim where we need to be bringing in the hospital or the medical staff involved, or is this still all attributable to that original accident?
It's a really interesting point you raise there about things being sufficiently negligent in terms of that bar, and I guess this is probably a question for both of you rather than one or the other, is that bar for negligence higher when it comes to trying to link both of these, or is it the same depending on each case?
Oh, this is quite interesting, sort of historically how it's been looked at.
I think, in my understanding, historically, we're talking back in, say, the 1900s, it was looked at as it would immediately break the chain of causation. We've got the injury, and then we've got this new medical act, and the courts were more willing to divide it in that way. But then we have in, I think it's around early 2001, this kind of case law which seems to set an idea that the medical profession needs to be grossly negligent, which suggests this really high bar for the medical professionals to break the chain of causation. That isn't to say that they could still be added in as contributing, but to be entirely responsible for that area. There was this idea that came about they needed to be grossly negligent. But at the moment, it seems from the emerging case law, which it's still fairly new, so we might be looking at some more change in the coming years. But we had a 2024 case, Jenkinson, which suggests that we're actually just looking at the regular standard of, is it so far out of foreseeability that it breaks the chain of causation? So in the simple answer to the question, no, it seems from the current case law that there isn't a higher elevated standard for the medical professionals in breaking the chain of causation.
It's really interesting, and obviously it's a law area that is developing probably all the time, I imagine, with cases as they come in. In regards to that chain of causation, how do you go about, proving that essentially, or developing those links? What kind of evidence is really looked after there in terms of helping highlight that kind of causation?
So again, this would come through from the medical experts and asking them, please look at the treatment, please look at the injury. I think, what as lawyers we have to be live to is, the injury we've got here, does that seem perhaps unusual for what this original accident was? Does it, does it seem, is this foreseeability point, is it reasonably foreseeable that somebody could end up in this situation based on that original accident, or does that seem unusual?
So what would kind of be an example of that then, out of interest?
So as I say, something like, you've had an accident, the result of which perhaps wasn't hugely severe, but you've ended up with an amputation, or you've perhaps had a neck injury, there's been a bleed that's been missed, you've ended up paraplegic, something of that sort, where you think, well, if that had been treated properly, and as it should have been, we wouldn't have been in this situation. A bleed would have been sorted, you would have had some symptoms for a little while, had some ongoing treatment, but you wouldn't have ended up as a paraplegic.
I imagine that all ties into, again, that kind of, not bar essentially, but making sure that connection is made between the two, as obviously there can be, I'd imagine, unforeseen consequences or conditions that can pop up as a result of being in a road traffic accident, for instance.
Absolutely. And of course, you always have to take the claimant as you find them. So, there can be instances where somebody, of course, has, an underlying condition already that perhaps becomes symptomatic, or, something of that sort, which wouldn't necessarily point to negligence. It's just something that, yes, would be from that original accident, but it's certainly something that you need to be asking about and thinking about.
Absolutely. I guess tying into that a little bit more, obviously, Rosie, appreciate you practice across both personal injury and clin neg. The difference between the two areas, I imagine, is something that not many, solicitors cover as a whole, or firms potentially. What are some of the differences between those two areas that makes it a lot more suitable to have someone kind of looking over how these claims cross over practically?
So I think sort of the major difference between the medical negligence and the personal injury is the situation of the claimant at the start. So, the majority of times, if you've got a medical negligence claim, there was already an injury or something wrong. Somebody was seeing a doctor or medical professional for a reason. So you already need to be thinking about, well, what would the outcome have been if that treatment had been performed correctly? Whereas with a personal injury claim, very often you're looking at somebody, who there wasn't a problem. They weren't seeing medical professionals for any particular reason. So, perhaps in that sense, it can be easier to sort of determine what the injury is, although both can be incredibly complex.
And I imagine, Rhiannon, how does that shake out in terms of a practical element when these claims are brought to you, essentially?
I mean, in a practical sense, personal injury claims are generally more simple and generally more on the black and white side. that even the standard of care for personal injury claims to be negligent, you're looking at what the reasonable person would have done. Whereas in the medical clinical negligence context, we're comparing them to the ordinary, the practicing guidelines, what we call the Bolam test quite commonly, that even this is more complex. So we're comparing to what do other established bodies and medical professionals do, and looking at the different options, that obviously it's not just one thought of what's acceptable medical treatment that's out there. So they're more complex. The trials are usually higher value. And of course, with higher value comes higher costs, and effectively, they're just more complex.
Absolutely. It's an interesting point you raise about different schools of medical thought, as I imagine trying to reconcile those, opinions from experts, as everyone, loves to say, let's get a second opinion from another doctor. How does that impact these type of claims generally? Is it one where you need to get that kind of raft of opinion from multiple sources to figure out what's the best? Or is it one where using an expert that you trust is a lot more straightforward?
I mean, with medical experts, if they're looking at sort of clinical negligence, you're looking at what would, is there a reasonable body of medical opinion who would have done the same? And if so, that's defensible. So, experts, their duty is ultimately to the court. They should, they will be reporting sort of on that, looking at what's happened and asking themselves, would a reasonable body of medical practitioners have acted in this way?
So if I'm someone who is obviously, for one word of experience, I've had a horrible time at the hospital coming off personal injury. I think there may be a negligence claim there, but I'm not entirely sure. What should I be doing as kind of a first step? How should I be getting that claim started?
So, we would always recommend go and speak to specialist solicitors, specialists in personal injury and clinical negligence. We'd recommend, ideally, if you can speak to somebody who will do both and can look at that for you, explain to them what's happened, tell them what's been going on, why you've got concerns, what those concerns are, and that can be investigated and explored.
Absolutely. And I imagine it's a lot easier having someone that can do both under one roof rather than having two firms, essentially, because then that's seeing information go totally lost in the void.
It can be quite complex if you've got sort of different firms doing it, because if you're looking at the same accident or the same event, you're both trying to recover damages for that same period of time potentially, and trying to work out, under which part of the claim you're claiming each, to make sure you're not either recovering twice for anything or not recovering at all.
Absolutely. And I imagine, Rhiannon, on a practical sense, having one kind of contact route through to you is a lot easier than having multiple sources.
Yes, certainly. Having the cohesiveness the claim brought as one is much, much easier in a practical sense, as Rosie has correctly said. It ensures that you're first not getting double recovery, which is a problem in itself, but also making sure that you are recovering something, that even when it comes to having all the parties there, it ensures the correct apportionment of damages. That if, for example, it can get a bit more complex if you have a car accident that you're partially responsible for, you might be seeing a reduction in the damages. So let's say you're 50% your fault. You might see 50% reduced from the amount you can recover from the other car's insurance, but that wouldn't come into the hospital side that you're recovering from them. So it's really important to have everything together so that these figures can be calculated, firstly, more simply, and secondly, more correctly.
It's an interesting point you've both made about double recovery, that kind of concept. I assume for obvious reasons it's something you don't want people getting paid twice for the same incident. But what kind of issues can that bring about in terms of, recovering a claim?
So I think it's quite complex when you've got this sort of situation, because, if you were saying that there's an apportionment between different defendants, and if you were perhaps saying, as a result of the original car accident, I've needed 3 hours of care per day, but I would have recovered within 6 weeks, but for then this medical event that happened. And as a result of that medical event that happened within a couple of weeks of this accident, I've also needed care, and that's continued, then we need to be very careful to say, okay, these are the hours of care that are attributable because of that car accident, and these are the hours of care that are attributable because of the medical negligence, and make sure that we're apportioning those correctly between the defendants.
How does that kind of get split split in terms of, is that, again, relying back on that medical opinion? Is that kind of putting in risk assessments? How do you define that split of care?
So that, that will depend as to whether you can split it out or not. So whether you're saying, look, they're all jointly and severally liable for this injury, or actually we can apportion it and say, this is where that divide is and this is what it would have looked like. If you can divide it, then of course you'd be saying, well, this is, what we're claiming against this defendant. And if you can't, then you're going to be putting it all into one, and then the defendants are going to have to look at apportioning it between themselves.
I think from my side, that's all the questions that I've got. But before I throw to the exit, is there anything either of you would like to talk about that we can cover?
And I suppose the only other sort of thing is, why these sort of claims are attractive potentially for defendants, and also for claimants. And I know Rhiannon has, already touched on this issue of contributory negligence, whereby, if you were 50% responsible for, let's say, a road traffic accident, so that's what we've been talking about predominantly here, you would be looking at losing 50% of your compensation if you were claiming it all against the insurer. So, if there is another defendant in the form of medical negligence, that makes that more attractive, because you're saying, okay, you lose 50% of the compensation against that driver, but you gain 100% of the bit against medical negligence. And equally on the flip side for insurers in particular, it can be quite attractive, because rather than them, paying out for something that's not entirely the fault of their client or their insured, they're saying, well, actually, we're responsible up to this point, but actually there's someone else who's going to be paying out compensation for the remainder of that claim.
And how do those discussions kind of go down normally? I guess that's probably not the easiest thing when you're
obviously we don't see it from, the defendant's side. But, there is, as I say, that's sort of perhaps a more attractive argument, for them. And, from a claimant's side, it's something, to speak to your client about very early on. If you're looking at sort of contributory negligence, where does that fit? How much of the claim is that against? And I think just having those discussions early on.
And there can also be tactical benefits of bringing in these clinical negligence claims that from the claimant's side, both yourself and the other, say we're talking about a road traffic accident, yourself and the other insurer might both have an interest in getting the opinion that says it's the hospital. From the insurer side, you might both have shared benefits of your two medical experts sitting together and bringing together these opinions. So there can be tactical perspectives in bringing in the other side and their medical experience. And from my understanding, from the claimant perspective, obviously you've got qualified one-way cost shifting, which can mean that by bringing in the clinical negligence claim, you are protecting your ability to recover greater damages mentioned in the contributory negligence situation, but with not as much risk as you might be looking on the defendant's side when these cases get a little bit more expensive and a little bit more complex.
So I imagine there's an element of mitigating risk there to a degree. Wonderful. Well, I think we'll leave it there for today. Rosie and Rhiannon, I'd like to thank you so much both for your time coming in and talking about crossover claims.
Thank you. Thank you.
Thanks for watching this episode of RWK Goodman's Legal Thinking Podcast. For more information on our firm's injury expertise, please visit rwkgoodman.com/injury. If you're keen to watch more from the firm, please feel free to subscribe here, or if you want to watch more legal thinking videos, please follow the playlist here. Thanks for watching.